Welcome to another edition of the Law New. Today our focus is on the law of conveyance. Now, conveyancing is a process or a mode rather that allows for the transfer of interest in property. Take for example an agreement of sale and purchase for land. By this document being executed, the effect of it is that the vendor transfers his interest in the land to the purchaser. So upon completion of the agreement, the purchaser becomes the owner of the land. Now, a conveyancing transaction consists of three stages. You have the pre-contract stage, you have the contract stage, as well as you have the conveyance stage. For the purposes of this discussion, my focus will be on the pre-contract and the contract stage. I would be highlighting some of the needs for each stage of this conveyancing transaction. Let us first consider the pre-contract stage. During this stage of the conveyancing transaction, what you do is preliminary inquiries. So it is always advisable that you retain an attorney at law. For the purposes of this discussion, and it being peculiar to the nature of an agreement of sale for land, the parties would be referred to as vendor and purchaser. Now, it is important that each party retain an attorney at law so that their interests could be safeguarded. Having said that, the attorney would then guide the party into searches being done at the respective registries, and this would be based on whether the land is held by transport. If the land is held by transport, well, searches to see if the title is a good one would have to be conducted at the deeds registry. If the land is held by title, then searches would have to be conducted at the land registry. Having conducted these searches and being convinced that the title is a good one and that this property is actually owned by the person who is selling it, one can then go on to do a physical inspection of the property. This would include going to the address of the property, walking on the land, checking to see if it suits the purpose for which you're buying it, whether it be for residential purposes or commercial purposes. Being so satisfied, one can then move to entering into a contract. This would be the agreement of sale. I would want to briefly consider some of the clauses which should be in this agreement of sale. To begin with, the parties to the agreement of sale, which are the vendor and the purchaser, their names must be clearly stated. The parties must be easily identified by their names. It is always advisable that you get proof of identification as well as proof of address. This is to ensure that there is no fraud in relation to the individuals concerned with the agreement of sale. Having established and clearly identified who the parties are to the agreement, it is next for the description of the property to be clearly stated. The description of the property is normally stated on the transport or the document which provides proof of ownership of the property. This can be either on the transport or the title. And that information is taken verbatim and placed on or in the agreement of sale as the description of the property. So the property must be clearly identified. Moving on, another crucial clause to the agreement of sale would be whether there needs to be a deposit or the price would be paid in full. Most agreements of sale allow for a deposit, which is normally 10% of the purchase price of the property, and that is paid upon the signing of the agreement. Of course, if there's a deposit being paid, the agreement must clearly state what would be the remaining balance owing to the vendor. This must be clearly stated in the agreement. Another crucial clause would be that of possession. When do the purchasers get possession of the property? This normally, in most agreements, you would find that that possession clause caters for the purchaser being granted exclusive possession upon the passing of the transport or upon when transport is given in his name. Once that is clearly stated, It is important that any other special conditions that are peculiar to the parties concerned with the agreement of sale and purchase be stated in the agreement of sale. One such condition would be that the property be free from encumbrances, because it is very well possible that you can have a situation whereby someone wants to sell a property but there is a mortgage on the property. Of course, upon the property being sent or upon the transport being filed at the registry, this would hinder the transaction going forward, or the property being placed in the name of another person unless certain things are done. So there you have it in relation to the contents of the agreement of sale. What is important to mention is that there must be some evidence in writing. In this instance, based on the example that I have given, it would be the agreement of sale, because section 3D4 of our Civil Law Act provides that there must be some note, memorandum, or writing evidencing the relationship, and it must be signed by the parties concerned in order for such a transaction to be enforced. There you have it on the pre-contract and contract stages of the conveyancing transaction. It is important that those conditions that are agreed upon are clearly stated in the agreement of sale. On a subsequent broadcast, I will discuss what happens after the agreement of sale is properly executed. Thank you.